Hi guys, California real estate attorney Viraj Garabedian here, and today I'm going to talk to you about the five questions I get asked most from tenants in my business. So the first question that tenants mostly ask is can I break my lease? And this isn't in any specific order. These are just questions that come up often, and so I wanted to discuss them with you guys. Can I break my lease? So sometimes tenants ask, what can they do to get out of their lease agreement? This depends on what type of lease agreement that they have. If their tenancy is based on a month-to-month lease agreement, a month-to-month lease, technically they don't have a term limit, so they can give a 30-day notice and they can basically vacate the property on the expiration of that notice. Or if they have a lease for a specific term, like a 1-year lease, then the lease contract will give them indication as to whether they can or cannot break their lease agreement. Most of the time, if they're within a fixed lease term, they cannot break the lease agreement until the end of the lease agreement is up, unless there are some exceptions to that. First exception is whether there is a termination clause in the lease agreement. Sometimes a lease will provide for the tenant to terminate the lease if some particular event happens, or sometimes for no event at all. And in exchange, the tenant can terminate the lease agreement upon giving a written notice to the landlord, or sometimes upon payment of a termination fee. Sometimes it's 2 or 3 months of rent. Sometimes another exception could be if the tenant is constructively evicted from their property, from the home, then that could also be a reason to break the lease agreement without the landlord's consent. But sometimes you can get the landlord's consent if it's already listed in the lease agreement. That can provide a way for you to break the lease before the term is up. The second question I get asked a lot is, what are my rights? And that's such a broad question because a tenant's rights in California are determined by two things. The one is the lease agreement that they have with their landlord, if it's in writing. And secondly, it's California law. And California law is determined by different factors. One of them is the Civil Code, California Civil Code. Another is the California Code of Civil Procedure. And then there's also case law that also is controlling on parties' rights in California. So the first thing to go to is the actual lease agreement that you have with the landlord to determine what the rights and obligations of the parties are. That's the first thing to go to see what the obligations you have, what your rights are, who's responsible to do what and provide what services, and to take care and maintain the property and the facilities and the appliances and everything else that happens. So the first thing to go to is the lease. If the lease does not say, and if it's silent on that particular issue that you're having, then you might have to consult with other sources such as California law and that sort of thing. The third question I get is, will I receive my security deposit back? And most of the time, this is after the tenant has vacated the property. But California law says that you are entitled to get your security deposit back within 21 days of vacating the property or giving the keys back to the landlord. And they're supposed to give you a breakdown of what services that they needed to use your security deposit for. If they're trying to withhold some of your deposit to pay for some of the services that they need to do, like cleaning, or if to fix something that was broken that was the tenant's responsibility, or any sort of issues that happened during your tenancy that was your responsibility to maintain or repair. They have to provide a written breakdown of those costs if they decide to withdraw them or withhold them from your security deposit. But in any event, there is a few exceptions to the 21-day rule, but most of the time you're entitled to get it back within 21 days. And if you don't, then the landlord could be on the hook to pay you a penalty for not giving it to you back in time. The fourth question is, my landlord is not fixing my home. What can I do? This can take the form of failure to repair your property, failure to fix things, failure to fix things that are his responsibility, or things that are the landlord's responsibility under California law, such as providing you with heat, providing you with running water, doors and windows that close and lock, facilities that work, plumbing that works. These are things that are required in order to be able to rent a property to someone in California. So some things you can do if the landlord is not being responsive to your requests to fix or maintain the property under California law are to first of all notify the landlord that they have an obligation to do that, if it is indeed their obligation. If the lease provides for them to do it, they have to do it within a reasonable amount of time. Usually that's around 30 days, within 30 days, or they have to take some sort of action to start fixing that problem within a reasonable time, or within the 30-day time frame. Everything reasonability is on a case-by-case basis, but in the most part, 30 days is considered reasonable. Another thing you can do under California law is it's what's called repair and deduct. It is a remedy that tenants have if they're not getting proper and prompt service from the landlord, is to do the repair on their own and take that amount of repair cost out of their next rental payment. This is for residential tenants. So amongst that, there's other things that there are other rights that the tenant has in regards to the landlord not fixing something that happened to your home. But for the most part, those are the main things. You want to look at the contract to see what the contract says. If the contract is silent on that, you want to consult with California law to see what the civil code or what the code of civil procedure says on that specific issue, and provide notice to your landlord that that's an issue. The fifth question that I get a lot is, can my rent be increased? And as of the date of this video, January 2024, there is there's rent control throughout the state of California. And so the rent control, a law was passed in 2019 called the Tenant Protection Act, which mandated rent control throughout the state of California, which describes how much landlords can raise their rent in California. It also provides reasons that the landlord can terminate a tenancy or terminate a lease agreement in California. So in connection with that law, there are requirements that some cities have made above that particular law, and it's on a city-by-city basis. Some cities have determined that landlords can only raise rents in a certain amount of money every year, a certain percentage, and that usually changes every year based on different formulas. Oftentimes it's called the CPI, or Consumer Price Index, and that is determined by an average cost of goods and services in the community where that property is located. So the answer to the question is can my rent be increased? First and foremost has to do with the lease agreement. What does your lease say? If the lease has already addressed that issue, then The next place to look at is California law to see whether that increase is in accordance with the law, and whether it is in accordance not only with the state law but with this particular city of the law that you're living in. And this is, and rent increases, the Tenant Protection Act and the percentage increases only apply to residential tenancies. Commercial tenancies are exempt from rent control. So that means that a commercial tenant and a commercial landlord can agree to raise the rent to whatever they want in their contract. And California law has nothing, does not mandate any specific limitations on that. Thanks for watching. If you guys have any other questions, leave them in the comments below, and I'll see you in the next video.